Council and the Secretary of State for Health, and Cornwall and Somerset County Council.
Lord Carnworth will explain the decision of the court.
Which of three local authorities is responsible under the National Assistance Act 1948 for supporting PH, a young man with physical and learning disabilities unable to make decisions for himself? Is it Wiltshire, where he was born in 1986, and which authority had responsibility for him under the Children Act 1989 until majority? Is it Cornwall, where his parents moved in 1991 and where he visited them for short periods? Or South Gloucestershire, where he lived happily with foster parents from 1991 until his 18th birthday? Since then, he has been living in care homes in Somerset. Responsibility under the 1948 Act depends on where PH was, quotes, ordinary resident. But by section 24(5), a person provided with accommodation under that Act is deemed to continue to be ordinary resident in the area in which he was ordinary resident immediately before that accommodation was provided for him. Hence, all agree Somerset is excluded. Similarly, section 105 of the 1989 Act provides that in determining a child's ordinary residence for the purposes of that Act, there shall be disregarded any period in which he was being provided with accommodation by the local authority under that legislation. Accordingly, his residence in South Gloucestershire had to be disregarded under the 1989 Act, but arguably not under the 1948 Act. The three local authorities jointly referred the question to the Appellant Secretary of State for determination. He decided that Cornwall were responsible because that was where his parents lived and could be regarded as his base under the so-called Vale tests, after the name of a judgment from 1985. The Secretary of State's decision was upheld in the High Court, but set aside by the Court of Appeal, which held that responsibility fell to South Gloucestershire, where he had been living immediately before his placement in Somerset. The Supreme Court allows the appeal by a majority of 4-1 and determines PH's ordinary residence at the relevant time to be in Wiltshire. The reasons in summary are these. The Secretary of State's choice of Cornwall was wrong. There was nothing in the Act to support the concept of a base determined by reference not to PH's residence, but to his family relationships. As for South Gloucestershire, although PH had been settled there immediately before his 18th birthday, that arose only by reason of his historic placement under the 1989 Act, which specifically excluded it from consideration as ordinary residence for the purposes of that Act. The underlying policy of both statutes was that ordinary residence should not be affected by the location of that person's placement. That helped to ensure that placements were made by reference only to the interests of the individual, not as a device for exporting responsibility to another authority. It would be wrong to interpret Section 24 of the 1948 Act without regard to the purpose and status of PH's residence in South Gloucestershire under the 1989 Act. For administrative purposes, his ordinary residence continued to be in Wiltshire, regardless of where they determined that he should live. That remained the position under the 1948 Act. Lord Wilson disagrees. He would hold that the established meaning of ordinary residence points to South Gloucestershire, where PH was living and settled at the relevant time, even if policy considerations might suggest otherwise.